What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Sunday. Happy Sunday. The end of a long weekend. So back to work for us tomorrow. Court's going to be open. Yay. 4-day weekends. Really long weekends are hard for me, for court channels. I had to deep dive for content this weekend. And yeah, I did my best. That's all I'm going to say. Anyways, hope you guys had a great weekend. Hopefully you guys had a great and safe holiday weekend. And yeah, you want to watch some court? I want to watch some court. Let's watch some court. We've got 2 clips tonight. The first one is a clip that Lucy sent me. Happened about a week ago. It's in Georgia. I don't remember the judge's name off the top of my head, but it's a neighbor battle that it's interesting. That's all I'm going to say. Second one is an injury lawsuit, and it's going to make you scratch your head a little bit. It's a little weird. Anyways, that's what I got tonight. Hopefully you guys enjoy it. But before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Be it.
Thank you.
Okay, thank you.
Next is position 21.
This is 25 CR 0073778J. Helen Williams Bolston, charged with 1 count of hit and run, duty of a driver to stop and or return to the scene of an accident, driving, striking unattended vehicle, and 3rd count of failure to report striking a fixed object.
So second, simple battery, family violence conviction was all I saw. That's it.
Okay. What year?
You know what? I didn't know that. Let me check.
1995.
Okay, that's why.
95. Okay, right. Thank you.
Yes, Your Honor. On October 16, 2025, City of Atlanta Police Officer Smith responded to a vehicle accident at 642 Leicester Street Northwest. The victim, James Arpad, a resident of 638 Leicester Street Northwest, reported that his neighbor, the defendant, backed her white pickup truck into his unoccupied parked Dodge Ram and also struck a fence on his property, causing visible damage. A second victim, Stephen Nunez, stated that Ms. Williams Boston also struck the front of his vehicle during the same incident. The officer observed minor damage to both vehicles and the fence, as well as matching damage on the defendant's truck, which was left at the scene. She had departed in another vehicle prior to the officer's arrival. On October 20th, investigator Tucker was assigned to the case. He attempted to make contact, but the defendant became confrontational and refused to cooperate. And on November 4th, investigator Tucker obtained an arrest warrant, and she was arrested yesterday. Your Honor, the state's recommendation is a signature bond through pretrial services on BHET, no driving unless she gets insurance, and no further contact with James Arpard and Stephen Nunez, no alcohol, drugs, or weapons while on bond. The reason that we're asking for not driving unless she gets insurance is because the state spoke with the victim, Mr. Arpad, who stated that he found out that she was uninsured, and now he has to pay deductible for his insurance in order to get his car repaired. He stated that the defendant is a nuisance in the neighborhood, and that all the neighbors say that she bothers them. He believes that the defendant may need an MHET.
All right. And I see a James there. Is that the victim?
Yes, Your Honor.
All right. Would you like to briefly address the court?
Yes, I would, Your Honor.
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth? And
Mrs. Biggin, good to see you. And thank you for the raid, Biggin. I appreciate it. Welcome to all the Biggin Raiders. Thank you for jumping over. We just started this case, so you haven't really missed much. Essentially, the police report was just read into the record, and the lady in jail, who actually I'm covering up, probably should change where my icon is. There we go. She's accused of a hit and run, and yeah, that's kind of it. And we're about to hear from the victim, the neighbor now. So that's about it. You haven't missed anything, but thank you so much for the raid. I do appreciate it. Thank you.
nothing but the truth under the penalty of perjury.
Yes, Your Honor.
All right. Thank you. And state your name for the record.
James Arpad.
Arpad. Okay. All right. And are you in fear of Miss Helen Williams Bolston?
Well, fear is probably not the right word. I believe that she has animosity towards me and may pose somewhat of a threat. She has been abusive and confrontational when I see her, and she has attempted to get other people that she knows involved in confronting me on her behalf. I do not live at the house next door. That was the one thing that was incorrect. It's a rental house that I own. But I have an ongoing trespass case against her for the vehicle that she parks on my property. And so this is what's led to, I believe, what's going on right now.
Okay. All right. I think I get it. So you don't want to have any more contact with her, obviously.
No, I prefer to have some sort of order of protection or something that stops her from approaching me, or I've had real estate agents that have come, and she's said things to them and been abusive to them with clients who are looking at the house. So if there's some way to preclude her from approaching myself or anybody that helps me, that would be awesome.
Okay. All right. Let's hang on for a second and mute yourself. Let me hear from her attorney first. Okay.
Okay.
Okay. All right.
Thank
Go
you,
ahead,
Judge.
Mr. Tamani.
Ms. Williams-Bolston is 63 years old. She's advised me that she's lived at her address for the past 30 years and that she also worked for MARTA for 30 years, but she's retired now. I believe her last arrest was in 1994. Judge, looking at the booking report, it says that her address is 644 Leicester Street, but she's advised me that her address is actually 6 Street, so maybe there's some sort of typo there or something. But we did want to just inform the court that her address is 642 Leicester Street. We would not object to a signature bond in this case either, Judge.
Okay. All right. I guess the problem is, James, how close is your home to her home? They're
It's
not next door.
They're completely next door. There's about 7 feet that separate the two houses. And the problem that has arisen in the last year is that she is claiming that somehow the city gave her ownership of my property verbally before I bought the house. There's a driveway between the two that's about 7 feet wide. So she insists on parking this unregistered, unlicensed vehicle there, and has broken down the fence that I've built to separate our properties. and is pretty much irrational about it. I've had a survey done. She's been provided the survey by my attorneys. She insists that her property rights are that the city has given her my property and I can go to hell, in other words.
So is there other civil litigation filed over this?
I believe it's in process of being filed. She's been served with papers that have asked her to stop her trespass. And I believe next week is when the actual case is being filed with the Superior Court.
Okay. Well, I hope you get to the bottom of it with not much more criminal intervention, but
Me too, Your Honor. Thank you.
I'll do the best I can here. It's only her second arrest. The other one was old in 95. I'll grant her a signature bond as long as Ms. Williams Bolston, you can tell me that you're going to not harass James. And it sounds like until you all get this sorted out that maybe you shouldn't be parking in that adjacent driveway. And will that maybe help you all to halfway get through this process by me giving her a. So let me ask this, the fence that she's alleged to have hit or something, is that on your property, James?
Yes.
Okay.
While she had moved her pickup truck, I had a fence erected to define where my property ended and hers began. And the big problem that I have is there's a door, a steel door leading to the crawl space of the house that is right where she keeps parking her pickup truck. So I've been unable to do any kind of repairs or maintenance underneath my house because she refused to move this pickup truck. So one day I was luckily passing by because I'm in the neighborhood every day and I saw that the truck was gone. So we quickly built this fence to protect access to the lower level of my house.
Escales, thank you so much for the 16 months. I appreciate it. Thank you.
The crawl space door. And when she came back, first she backed her truck into my truck. Then she turned around and drove into the fence and broke down the fence. And all the pictures of this are enclosed in the police report that Officer Smith filed. And then when Mr. Nunez drove up, she drove into his truck to stop him from coming up the street. After that, she tried to get several people who live on the block to attack us to say it was our fault that she did this, and then drove away in another vehicle that she owns that I believe is not insured either, and did not stay for the police to come and file the report, which is why it became a hit and run.
Okay.
But if she was to move her pickup truck, which is illegally there, it hasn't been licensed in 2 years, that would resolve so much of the problems and allow us to move forward with.
Dan, good to see you. You're gonna love the next case. It's not a criminal case. Let me just say that. At least I don't think it was. It's a lawsuit for someone tripping over something in a store, and it's really interesting. But I was thinking about you when I was listening to it. I was putting the video together. Good to see you. Also, wait, I already forgot what I was gonna say. Okay, let's go.
My selling the house and never dealing with her again.
Okay. So I will order, and let's see, with the hit and run, that's $1,000. Driving, striking an unattended vehicle, 500, and failing to report striking a fixed object, 500. So that'll be a $2,000 signature bond.
Level 1, you good?
Yeah,
Oh,
level 1, for pretrial level 1. I'm going to order the defendant to, she can still park her car, I'm assuming, on the street in front of her house.
Oh, absolutely, yes. In fact, I think code enforcement had already um, talked with her, cited her for having. There's another car as well that she parks on the sidewalk that has been unregistered and uninsured for like 4 or 5 years. So I believe they've offered her, or rather ordered her to move the vehicles, but I don't know the status of that.
Because I'm making sure if I say in the interim that she not park in this adjacent driveway, that she have sufficient, ingress, egress, or sufficient way to get on and off her property by parking on the street till you all can get this driveway situation resolved.
Yes, Your Honor, absolutely.
Okay. And so do you understand that, Ms. Williams Bolston? Are you going to be able to do that? Can you hear
Yeah.
me?
Yes, ma'am. I do hear you. Um, may I address just a mention, please?
Okay, and tell me why.
The reason why is that, and I was told not to get too deep, so I'm just going to try to be simple. Um, the situation that Mr. Arpad and Mr. The other gentleman is describing to you is completely misleading, and that everything that he's shared with you is not correct, and I can tell you why.
Yeah, it's just that this is not an evidentiary hearing. This is just for bond. So I'm trying to kind of, if I can, make the peace for a moment until you all rather can get into court further. And in the interim, if this driveway is the bone of contention with you all,
okay, I understand.
I was making sure you could get on and off your property without parking in this driveway that he claims is on his side. He'll have to prove all that. But in the meantime, I want to know if you can stop using it to get on and off your property.
Unfortunately, no, ma'am, I won't be able to. And reason being, Mr. Arpad is really trying to steal property, and this truck, what he's talking about, our property line is right in the middle, and he's trying to place me within his scope of work that he's doing in his house, which allows him to encroach on my property. Everything that he's saying to you, he has encroached upon me. There has not been any fence erected on the property, other than the fact when I went to breakfast, he built something really quick in 30 minutes, where I've normally been parking for 30 years. Not 1 year, 2 years, 30 years. I have proof that I own this situation, but he's a very powerful, got plenty of money, and I'm unable to fight him because I am a legacy resident, and I'm only under $1,800 a month, and he knows it. So yes, we are going to court. Yes, I am going to do a civil suit against this man, because now I am just completely thrown by his remarks. So to answer the question, the parking, my truck will be there until we go through court, because he's already placed his survey way beyond the encroachment spot. So therefore, my vehicle will be there until after we go to court, which is on the 1st.
Oh, you all go to court on December 1st?
As far as I know, yes, ma'am, and that's why I was detained yesterday. I was supposed to be in court, family court, to take a TPO out on him because he has been harassing me, but the police intervened and put this warrant in front of me, and I couldn't make the court date yesterday at 2 o'clock. So now I'm in this situation, which he pushed forward with the officer coming to my house and bullying me about James Arpad himself.
Okay, so with this,
Yeah, not a lot of that made sense. I mean, I don't know. I don't know if she's right about the property line. I mean, I have no idea. I don't think anyone really does. That's not those two or the surveyor right now. But yeah, they put a warrant out for your arrest because you damaged his car and his fence with your truck and then left. Yeah, that's why you had a warrant. Real quick, Dan, thank you so much for the super chat. I appreciate it. Always good to see you, good sir. Thank you, Dan. Great Granny thank you so much for the month. I appreciate it, Great Granny. And Dr. Gonzo for a member for 2 months. Thank you. Vehicle. Thank you, Dr. Gonzo. I appreciate it.
Adjacent driveway that goes in between both properties. What's the suggestion as to what I do? Or else we're gonna have them back in same situation. State or Mr. Tremonti, what do you all think?
Your Honor, the state has asked, I did put it in, if we could just order no contact with the victim, it seems to be a dispute as to who the driveway actually belongs to. That's something we cannot resolve today or even have jurisdiction to resolve. So we would just ask that the signature bond be put in place and no contact order. I think that resolves or addresses the issue before this court today.
And I would agree with that.
May I
Well,
say
if we think they're
further?
able to not have any contact, we'll see what goes there.
Your Honor, may I speak?
Yeah. Yes.
Thank you. I do believe, that everything that has been said is completely inaccurate. There is another person, Steve Nunez, who was a witness to everything. And I think I understand this is a bond hearing, but yeah, the vehicle is unregistered and unlicensed, and that is a city, county, and state violation. And I don't know if you have any import onto that situation, but that is against the law for a vehicle to be on city property, whether it's on your own personal property or on somebody else's property. That is illegal.
All right, now he's just narking. That has nothing to do with this case. And what are you trying to do? The judge can't file charges against her. I don't understand what you're asking for here. I think this is a bit much. He didn't need to say that.
And so is it still there now or has it been moved?
As far as I know, it's still there, Your Honor. It was there 2 days ago, the last time I drove down that street.
And it's parked so that, is there someone in the house next door that lives there or or it's not occupied?
Right now, it's not occupied. The tenant had moved out, and I would need to do work on it to be able to sell it or rent it. But I cannot get into the vehicle pulls up within 6 inches of the house and blocks me getting into this steel door access to my basement, to my crawl space. So I am unable to do work that I need to do on my own house. I can't rent it. I can't sell it.
Because her truck is still parked there.
Correct.
What are you going to ready to say, Ms. Morris? Help me out.
This needs to be addressed in civil court. We can't address this. We have no remedy. We don't have any facts. We don't have any issues. We've heard what the concern is for Mr. James, but this is not our purview. And I don't think we have a lot of cases. It's not that this is not important, but we have a lot of people waiting to be heard. And I don't think we can resolve this. We don't even have the information to address it.
I understand.
The problem is that the criminal charge of hit and run is hitting, and I'm not for sure about hitting what she hit and ran from, driving, striking an unattended vehicle, failing to report it. So did she strike a vehicle of yours or whose vehicle?
She hit my pickup truck, and then but I was not in it. I was outside on the sidewalk. But then she did run into Mr. Nunez's pickup truck, and he was driving it. He was in it.
Okay.
Yes, Your Honor. So the hit and run is for striking Mr. Nunez's car. He was driving it at the time. For Mr. Arpad, his vehicle was unattended. That's the other charge. And
That's
then
the
for
other one.
striking
Okay.
the fence as well. Yeah.
Okay. And now I'm clear. So we have those charges, which, I agree they're still coming from a civil incident, property dispute incident. And now we have these charges, which are criminal in nature, but they still are arising from this civil property dispute.
Yes, Your Honor. So the state is asking for the signature bond, not driving unless she gets insurance, no further contact with Mr. James Arpad and Steven Nunez, to stay away from the incident location, 638. Alcohol, drugs, or weapons while on bond. The state recommended a BHET based on what we heard from the victim. But we can defer to the court if you think that the BHET is appropriate.
If I order the stay away, and I would definitely, because these parties certainly need to do something in the interim to resolve it, are they going to be able to stay away if her car is there, can't be moved because it has no insurance? And I just don't see that we're resolving anything with the stay away.
I would say that it's Miss, I forget her name. I'm so sorry. The defendant's is not to have contact with him. I mean, but we can't order her if this is her property and we're going to tell her to get off of her property. We don't know. That's why I said I don't think we can. We don't know whose property it is. We don't know who's telling the truth. We don't know what the survey says.
Right. This is an adjacent driveway that goes between the two properties.
They may both.
At this point, the line is somewhere in between. And so what I'm getting at is they're going to be right back here if she's not going to move her truck. If the truck is still there and it can't be moved because it has no insurance, and he needs to get on and off his property as well.
So maybe we say they have no contact directly. So, I mean, if they are no contact directly, so they should not talk to each other. They should not engage with one another. They should not be in each other's presence. But if she parks her car and he happens to be on the other side, she needs to go about her business. She does not need to engage him. She does not need to interact with him. She needs to go as far as possible. And so I know she can hear what I'm saying, but I think that's all we can do at this particular time.
So
all right.
Sorry. Yeah. May I say something?
Quickly.
One more thing. Yes. Because the vehicle is uninsured and unlicensed.
That's not before the court today.
The court has no leeway to say she was driving this vehicle illegally. That is criminal. Can the vehicle be required to be removed from her possession?
Oh, no, I can't.
Okay.
I mean, removed from her possession. What do you mean? We're not going to confiscate the vehicle.
Off the premises because it's violating state law.
I can't do that. I don't know because I don't know that it is technically. Okay. And I think ASG Mars is with me. I don't know that it is illegally on her side or your side. That part I couldn't tell you. Certainly she's supposed to have it insured to drive it. So if she keeps driving it uninsured, I guess you call the police and say pick her up again for driving without insurance. I mean, that will take care of itself. But if she's hitting your vehicle and the other vehicle or hitting the fence, those are things that she can be ordered not to do or to pay for the damages resulting therefrom. I just think that for me to order her to move her vehicle from the adjacent driveway until it's determined that she's violated something by parking it there, I don't know.
No, that wasn't what I meant, Your Honor. I apologize. Okay. I meant because it's an unlicensed, unregistered vehicle. Well, state law says it cannot be on any residential property.
Well, I don't know that the law says because it has no insurance. Is it no? Because she's not even charged with that. No registration. She's not even charged with that.
I don't know why not.
It wasn't like she was driving it down the street and got pulled over when they ran the tag to saw that it was expired. That's not what the charge is.
Okay. So correct? That charge was not
ASG
included?
Can we?
No,
yes.
That's not before the court.
Can we move on?
Yeah, she's not charged with that.
Okay,
so all I'm going to order is that's not what the charges are. And I read the hit and run, driving, striking unattended vehicle, and failure to report striking a fixed object. So I'm just going to order again that she stay away from your property, wherever that may be, that she have no further contact with you. The two of you should have no further contact. She shouldn't have any contact with you.
Which is good.
I think as ASG Morris said, not talk to you, not have any interaction. However that needs to go.
I'm so sorry. Is there any way, because she did try to bring other people into what she called defending her against myself, and she's been giving petitions in the neighborhood for people to basically attack me. And I think that inciting people to attack me would be something I'd love to be protected by.
Then
Mr. James, do you have our witness advocate number? Because we can call you later. Do you have you spoke to witness advocate, right? So you can call with you, contact them, let them know what your concerns are, and we can address the court. We can bring them to the court if we feel they're valid. But right now, the judge has made a decision as what she wants to do with this case. We welcome to hear any other concerns you may have. Please give our victim advocate a call. I think that's Ms. Calloway who you spoke to today. Let her know what your concerns are, and we will address them with the court at a later date.
Will do. Thank you very much.
Thank you, ASG Morris. And that was a 2,000 signature bond through pretrial.
Level
one. Yes,
and,
level 1.
And the conditions is no further contact with the victims and stay away from the property of 638. And then you put no driving unless obtain adequate insurance or registration on the vehicle owned by the own or drive. And no drugs.
I guess I can throw that in, even though that's not before the
court. No drugs, or alcohol, weapons, or firearm. I just want to make sure I got the order right.
I'll throw it in for what it's worth, but I'm wondering if I should even take that out, because she knows how to follow the law with that, but she needs to really get charged with it before I tell her that.
I'll always put it in there regardless. She does.
Yeah, we'll throw it in. We'll throw in that because I guess she could be arrested for it if she doesn't get the truck properly insured and tagged.
And that's registered. And nothing else. I just want to make sure. And there's nothing else about the parking.
No, I'm not going to address that.
Okay. All right. I just want to make sure I got the orders correct. That's all.
No. So ASG Mars will be representing me. I tell you, of taking me further into it. And Mr. James, maybe you need to consult an attorney.
Oh, my attorney is filing the case next week. Everything is.
Oh, well, good. Then you guys will be over in the civil court to.
We will be there. Yes.
Great.
Thank you, Your Honor.
All right. Good luck to you.
Appreciate you.
All right. Thank you.
Thanks.
All right. Bye-bye.
Oh, man. I didn't think that case was ever going to end. That guy just would not stop talking. Tammy, thank you so much for the 9 months. I appreciate it. And Sir Philip Heels. Actually, it's not Sir Philip Heels anymore. Sir Philip of Sea Lake. Thank you for the 22 months. That is awesome. Thank you. Okay. Next case, we are jumping courts. We're staying in Georgia, though. We're going to Judge Hayward's courtroom. And, yeah, this one's interesting. It's good, but it's interesting. Let's go.
All right, so the next case is the Capital, oh, no, I did that one. Carmen Robinson versus Cerrito Western Wear. Are we ready? Case 2024 CV 04572.
Phil, thank you so much for the 5 gifted memberships. I appreciate it, Phil. Welcome to the 5 new members. Let's go.
Yes, Your Honor. Your Honor, Edward Alo on behalf of the defendant. This was the defendant's motion for summary judgment. I did prepare a PowerPoint presentation. If I could have court's permission to share that.
You may.
Does anyone else kind of cringe when lawyers use PowerPoint? I don't know why. I just like, I mean, it makes sense, I guess. It's, a way to read your notes and stay on task. But I don't know. Every time I see it, I'm like, man. But I just feel that way about all PowerPoint presentations. So I guess I'm judging PowerPoint.
As I mentioned, Your Honor, this is the defendant's motion for summary judgment. I know the court just heard a summary judgment motion, but just to refresh the court's recollection, summary judgment is appropriate whenever there's no genuine issue of material fact that shows the movement is entitled to judgment as a matter of law. This is a premises liability matter in which the plaintiff is claiming, as an invitee, she suffered injuries on the property. The general rule whenever it comes to these premises liability matters is that a plaintiff is not entitled to recovery as an invitee if the undisputed evidence shows the plaintiff's knowledge of the alleged hazard was at least equal to that of the property owner or possessor. In this particular case, the defendant offered 3 specific issues to show why we were entitled to summary judgment. The first being that the evidence in discovery at this point, there's no evidence that actually shows that this subject stool, which the plaintiff claims that she tripped on and fell, there's no evidence that shows that that subject stool actually caused the plaintiff's fall. The next basis would be that the plaintiff had constructive knowledge of the stool because the stool was a static condition. And lastly, the knowledge of the stool would be imputed on the plaintiff, therefore giving her at least equal knowledge of the stool under the prior traversal doctrine. So just going along the lines, the plaintiff's claims are brought under OCGA 5131, which provides for liability on an owner possessor of property for injuries caused to an invitee for failure to exercise ordinary care in keeping the premises safe. Going to this specific matter, Your Honor, the plaintiff's own testimony said that she walked into the store on the day of this incident. She had walked around the store for, I believe, about 30 minutes looking at the products and the inventory before completing her transaction. Assuming she would have been facing the counter, turned to her right to then walk towards the entrance/exit, and after taking a couple of steps, fell to the ground. She testified that she never saw the stool prior to the fall at any point. She testified that she believed the front of her right foot struck the stool and caused her to fall, but she has no memory of actually making contact with the stool with her right foot. She, again, never saw the stool until she was on the ground, and she further stated in her deposition that her only basis to believe that the stool caused her to fall was because the stool was in the area. It is clear from Ms. Robison's deposition that she does not know what actually caused her to fall, and rather her testimony regarding the stool causing her to trip and fall is just speculation. And Brown versus Emerson, Georgia Court of Appeals, which is 220 GA app at 318 in 1996, says that speculation is not enough. Speculation is not enough to survive a summary judgment motion. And I believe a photo of the stool was included as part of the summary judgment motion. If it wasn't specifically, it was an exhibit to Ms. Robison's deposition, and this is actually exhibit 2 to Ms. Robison's deposition. So,
was there video?
There was not, Your Honor.
No store. We got a retail business that doesn't have video?
It did have.
There was video.
There was
they've
video,
not-
but it wasn't preserved in enough time. I believe it was written over before they became aware of the claim. So as I mentioned before, premises liability is rooted in this idea of the possessor owner superior knowledge of a condition. But if nothing prevents the invitee from seeing the hazard, then there is no liability on the owner or possessor, because it's presumed that the invitee had at least equal knowledge of the condition as the owner.
So in a retail store, the basic premise is that you're going to keep the items for sale at eye level. The most attractive items are going to be at eye level, so that the person who's perusing the merchandise is going to essentially be looking at those things that are for sale, maybe a little bit lower table where I can look down and reach down and pick up an item. But is this a store where she would have been compelled by the placement of the items to look on the floor or at floor level? Because when you said stool, when I read the briefs, I'm thinking like a stool that somebody would sit at a counter. But in this case, this is one of those little step stools that you put to assist you in getting to a higher shelf or something. So is there anything that would have compelled her, since the basis of your motion is that she would have had equal or superior knowledge, is there anything that would have compelled her to draw her eyes down to that level as opposed to looking at the items for sale that were presumably higher than the stool?
Sure. So I think what the court is getting at is the distraction doctrine exception to the static condition doctrine. So let me shift to that.
Yeah, I took a lot of words to say that, but yeah.
So essentially, yes, there is an exclusion to the static condition doctrine under the distraction doctrine. In essence, the distraction doctrine is whenever the possessor of property creates a distraction which diverts the customer's attention, allows that hazard, and in this case would allow the stool to be the proximate cause of the injury, setting aside the static condition doctrine. However, if we go to Sears, Roebuck and Company versus Chandler, the Court of Appeals, I believe it's this one, has said that, this attention-seeking merchandising and signage is enough to be considered a distraction. However, there still needs to be some evidence from the plaintiff that says that they did not see this stool because of, they were looking at the merchandise, they were looking around. There needs to be that type of evidence there. But in this case, Your Honor, there isn't. Ms. Robeson was actually asked, about that, and there is arguments by plaintiff's counsel that, her view was obstructed because of a shopping bag. But that is only argument. We have to actually go to Ms. Robeson's testimony, and she had been asked multiple times and said multiple times in the deposition, she just did not see the stool because she was not looking for it. She did not say or otherwise testify that she was distracted. She did not say that the view was obstructed. She doesn't recall really what she was doing. She was saying, she could have been doing this, that, or another thing.
Sparkle Boots, thank you for the super chat. What am I missing? Because right now this is a pathetic display of graduated law school. I don't think he's doing a terrible job. I mean, I'm not a fan of the PowerPoint, but the second I said that, Rob and Dan both said they use them. I was like, all right, maybe it's a good tool to use. Besides that, I don't think he's doing a terrible job. I can't wait to hear the other side of this, though. I think that's going to be the interesting one.
She doesn't really recall what she was doing, but she was very clear multiple times in her deposition that she did not see it because she was not looking for it.
Okay, let me ask this. What you keep saying that the stool was a static, it was static, but it's a movable stool, and the purpose of the stool is to move it from place to place in order to access the higher, access things on a higher vantage point. So was that stool there all the time, right in front of the retail counter, or did it move from place to place?
So first, I just want to break apart two things in terms of while the plaintiff was at the store, there's no evidence that the stool had been moved from the location it was at the time of the plaintiff's fall. There's no evidence in discovery. But just generally speaking, yes, there is testimony that the stool would be moved to wherever it was necessary. I believe one of the employees at the location was vertically challenged and used the stool to be able to reach up higher and would need to get up and move that stool as
It's my
necessary.
turn. All right.
But that being said, this movable object idea is something that the plaintiff did bring up in her brief. And if we go to, there are multiple cases that have said that just because a condition can be moved does not prevent it from being a static condition. The definition of a static condition, and I can go back to that slide, is a condition that does not change and is not inherently dangerous. It is an open and obvious condition, if nothing prevents that person from seeing it. Going to the cases where courts actually considered movable conditions, I'm going to butcher this, Gallacher versus Dollar Tree Stores, which is Northern District of Georgia case from 2025, and that's 2025 U.S. District, Lexus 123101. They specifically found that an A-frame sign, like a what for A-frame sign, constituted a static condition. In Rents versus Prince of Albany Inc., it was at a car dealership where they found that a cornhole set, which, cornhole set is a movable condition, and that constituted a static condition. And then finally in Barwick versus Dillard House Inc., and that's 2023 U.S. District, Lexus 241312, Northern District of Georgia, 2023, specifically held that a movable object can fall into the definition of a static condition, as long as it is a condition that does not is not obstructed from the plaintiff's view. And again, Your Honor, in this matter, she's not claiming that it was hidden. It wasn't like under a pile of clothes. It wasn't under a pile of anything.
So your argument is entirely based upon the fact that while the plaintiff alleges that she fell due to something in the store, there is no evidence from her testimony of what either it was actually that she fell upon or fell because of, like, the stool was there, she may have, but there's no evidence that she actually made contact with it, or there's no evidence also that her view was obstructed by anything that would have been present, either clothes, or she hasn't stated those things such that there's evidence that a jury could consider.
Absolutely, Your Honor, yes. And just going back to, the static condition doctrine, the courts have been very consistent. The Court of Appeals, as well as the Georgia Supreme Court, has said that the invitee's failure to look, or even just the invitee's failure to see a static condition, does not relieve the invitee of responsibility for not seeing the static condition. Just because you didn't see it doesn't mean there is a breach of a legal duty.
Okay.
I am arguing those two alternatives. And then the last issue, I already talked about the visibility exclusion. There's nothing that she said that the lighting wasn't sufficient, nothing that she said that obstructed her view. She just didn't see it.
All right. And as a former shopper, less so now, but there's a tendency to pile a bunch of things in your hands, mm-hmm. especially if you're in a higher end store that doesn't have a buggy, yep. To take them to the checkout.
So, Your Honor, she had actually the plaintiff had actually completed her purchase and was leaving at the time of this fall. And I believe she did say she had a bag in her hand. She didn't remember how she was holding it. She said it may have been in her right hand, but she just doesn't recall.
And she didn't hit the stool on the way to checkout.
Correct.
Okay. All right.
And she did say, oh, go ahead, Your Honor.
Well, because part of the equal and superior knowledge would have been had she goes up to the checkout to check out and the stool was there, then she moves away from the checkout and the stool was there, but on the moving away, she hit it. So the argument, I guess, is, did she appreciate that the stool was there as she approached the checkout and was able to see it at that point?
So, Your Honor, I believe what the court may be going to is the prior traversal doctrine. So let me get to that. So the prior traversal doctrine is judicially stated that when a person has successfully negotiated an alleged dangerous condition on a single previous occasion, that person is presumed to have knowledge of the condition and cannot recover. It's not necessary for the person to have actual knowledge of the alleged condition, but rather to have been in that area and successfully, I guess, avoided the condition or avoided the harm that was subsequently incurred. So all that's needed is that one single action. It doesn't have to be multiple times. It just is a single prior traversal. So going to the plaintiff's testimony herself, as I mentioned before, she had spent about 30 minutes in the store before completing her transaction and the fall occurred. She testified multiple times that she never saw this stool prior to the incident. And in those 30 minutes, though, prior to her fall, she conceded that she walked around the store. She walked around looking at all the merchandise. And she actually admitted, and this is page 88 lines 5 through 13, as well as line 25, and page 89 lines 1 and 2, where she conceded that she actually walked in the area where she fell, in the area where the stool would have been prior to her fall. So this, Your Honor, establishes at least one single prior traversal of the area without issue to establish, that the knowledge of the stool should have been imputed on the plaintiff, establishing, no liability per the prior traversal doctrine. It's our position, Your Honor, whenever you look at the stool on the flooring, it's an open and obvious condition. It's just, whether or not the plaintiff, she didn't see it. There's no ands or buts. She did not see it. She's testified to that. And it's our position that, her failure to see it does not establish a breach of duty on behalf of the defendants.
And the stool, would we have considered that it was properly placed there, or in a place where it would not cause a hazard? Or doesn't that matter?
I don't believe that matters, Your Honor. As long as it, is an open and obvious condition, as long as, nothing is obstructing the invitee's view of the stool, the plaintiff isn't distracted or can provide the testimony that or doesn't provide testimony that she isn't distracted by the merchandise or things like that, then it falls under the static condition doctrine.
Okay, and last question, from the picture, what I ascertain is that where the rug is would have been where the checkout part was?
Yes, Your Honor. And my apologies, this photo might be a little bit misleading. We don't actually, this photograph was taken like as an exemplar, because we don't actually know.
Yeah, I didn't think that it was the actual taken at the time. I'm just trying to get the setup so that somewhere in front of this counter was the stool.
So it would have been, according to the plaintiff's testimony, where she believes she fell. I believe she checked out here at this counter. After she checked out at the counter, she would have taken, I want to say it was like 3 or 4 steps. This is in her deposition testimony. So if Your Honor wants to go back to her deposition testimony and review it, she took 3 or 4 steps, which would have been to the right of this photograph towards the exit. And that's when the fall occurred. And it wouldn't have happened. It did not happen like right up against the counter, but rather it would have been closer in area and in space to the person that was taking this photograph.
Okay. All right. Mr. Glass?
Yes, ma'am. There's a lot to unpack. Literally what Mr. Allard just said, his very last statement, that's just speculation. She doesn't recall where the stool was. And I say she, I mean Miss Serrano and the plaintiff. Okay, so I'm gonna go all the way back to the very beginning because the first argument that the defense brings up is that she can't even prove that it's the stool that tripped her. The employee admits in her testimony, was it, and I'll give you, I hate to just recite the brief, but was it then that you could see she tripped over the step stool? The employee's answer was yes. How did you know it's the stool that tripped her? Answer, it was the only thing that was like on the floor. Then the plaintiff testifies, I know, I was just walking and I tripped over a stool. That's, I mean, that is on its face, her saying that she tripped over the stool. She goes on and says, I just know that I hit it and I fell.
Sparkle Boots, thank you so much for the super chat. Attorney fee fund for that poor little step stool. It does look it's so little. I mean, it's like, what, a 6-inch step stool? It's bigger than that, but it just looks so small in that picture.
Again, direct testimony that she hit a stool and fell. So I just want to put that to bed. In her, and you can go back and review her deposition, but plaintiff's counsel asked her many, many different questions, and at times she just didn't answer exactly like, I hit it and I fell. He circled around it many times. So if you want to go back and review it, there's plenty of testimony that says that she hit it. And that's what tripped her. I also want to go back to Ms. Serrano's testimony, which is extremely important because it speaks to this entire argument about whether it's a static condition. I asked her point blank, do you know how the stool was placed in front of the counter? She says, no, I don't remember who put it there. There were 3 people working there that day, and I don't know who put it there. So to speculate and say it was sitting there for 30 minutes, he can make that argument to a jury, but he can't argue it to the judge because that's not a fact. That's a disputed fact. It could have been there 5 seconds before she turned to walk out of the store. We just don't know. The one employee that could have testified to it says, I don't know how it got there. Presumably when it was there, she has no idea. All she knows is they moved around the store to use it, which you correctly asked in your question to defense counsel. I highly dispute whether this is a static condition. A jury should decide that, first of all. But it's 10 inches off the ground, and it's used to help people reach things that are higher up off the floor. And she testified all of them are short. So presumably this stool got moved all over the place. And most importantly is we have no idea how long the stool was there. The jury can decide that, whether or not they think that stool was there for 5 seconds or if it was there for 30 minutes. The bag that's been brought up that was handed to her, it was at the deposition. I don't have a photograph. I don't have the same, but it was used at the deposition. We did measure it. It's 20 inches by 23 inches wide and tall. That's almost 2 feet by 2 feet. And it's 17 inches wide once you put items in it because they sell a lot of cowboy hats. So because they sell a lot of hats, these bags are very big. And she acknowledged that was one of their bags that we brought to the deposition. So I asked her, for the sake of, I hope it didn't sound really dumb to Miss Serrano, but how does a sale take place? You hand her the bag over the counter, correct? And she says, yes. And I said, well, did she drag it along the counter as she was looking, to see this stool? And it was such a weird question for her. She's like, I don't remember her dragging the bag. So she would have turned with the bag like any other customer, and that's going to block your view of this little 10-inch stool on the floor. Lastly, the defense makes an argument about whether or not it's open and obvious. Again, this is a question for a jury, not for a judge. We're talking about a stool that in the photo, it looks white, but there's gray dots on top of the stool. You're talking about a gray floor. No one can really pinpoint exactly whether it was up next to the counter. Presumably it was because she testified we used it to reach up and touch merchandise. So it wasn't 2 feet off. And defense counsel's correct. Many, many times he asked and tried to say that maybe she traversed that area or she saw the stool. At no point does she say she ever saw this step stool. So for all we know, one of the employees was helping someone else in the store while she's shopping and popped that little stool out 10 seconds, or even while she's checking out and buying her stuff. There's just no testimony to it. So the very beginning, counsel said it has to be undisputed evidence for the court to find in favor of the defendant. And we have a lot of disputed evidence. We have disputed testimony for the jury to decide. I did spend some time in my brief talking about whether or not this is a static condition. Defense just brought 3 cases to the court that I've never seen before and presented them to you. It was not briefed about what is a static condition. So I would argue an A-frame, which by the way, I have no chance to review those cases, but I would assume an A-frame is a lot taller than 10 inches off the ground. Cornhole boards that I've seen are huge compared to a tiny little step stool. So I don't know if in those cases that was considered, but the cases that I found were mostly about objects that are not movable per se. You know, they're placed there, and clearly this was moved all over the place. And they even kept it in two different places in the store. They kept it in the storeroom and they kept it right behind the counter. Your Honor, I want to go back because I did obviously take notes leading into this hearing. I wanted to highlight to the court there is a Walmart case from 2006 where the court found it was a factual issue for a jury to decide when a fan was placed on a high shelf. The jury needs to decide if the business knew or should have known it was a dangerous condition. In our case, I asked the employee, do you believe that a step stool is a dangerous or a trip hazard? And she answers yes in her testimony. So the defendant admits that it's a dangerous condition to have a little step stool around the store. And that, you know, in the Walmart case, that was for the jury to decide. And in our case, I don't think the jury's going to have a hard time figuring out that this was a dangerous condition. It also highlights the Perkins case, which is from 2010. I really like the Perkins case because it's a little more on point for us, and it says that an invitee is entitled to assume that the owner-occupier has exercised reasonable care to make the premises safe for the invitee. And here's the key part, and continues to exercise such care while the invitee remains on the premises. So this would be something I would argue to a jury, that they were not continually exercising care by moving this stool around, presumably while she was shopping. That's a question for the jury. And so for today's purposes, plaintiff would put that there are multiple questions and that the defendant's arguments fail just on the face because there is disputed evidence, given the fact that it's not a static condition, one, and two, they have no idea when the stool was put there or how long it was sitting there. And all of that is a big predication for the defense to win their argument, is that she priorly traversed this stool. Well, there's no evidence of that. She didn't see it. Obviously, if she'd seen it, she wouldn't have fallen over it. And then their own employee admits, yes, that's a tripping hazard. So we thank the court for your time. If you have any questions, happy to answer them.
All right. Mr. Alla, anything else?
Yes, Your Honor, just briefly. First, Your Honor, the duration of time that the condition existed, it has no bearing on the static condition doctrine. There is absolutely nothing in the static condition doctrine. Whenever you go to the case law that enumerates it, and it's cited in the defendant's brief as well, it just requires.
Do you mean that there's no specific amount of time that it is required for it to be considered a static condition? Because the nuance for me is that if the plaintiff walked away to the other side of the store and the stool was moved to go get something, and then the employee brings it back and puts it there, it doesn't have to be there for 10 minutes to be considered static. But if the employee, when she turns her back, that stool comes in and is placed in front of the cabinet, it's not moving at the time that she would have come back to the counter. But the fact is that I'm not talking about a particular time limit. If she walks away from the counter, stool's not there, she turns her back, the stool is placed there, she comes back to the counter, it's not particularly static because it moved between the time she moved away from to the counter and away from the counter.
So, Your Honor, a static condition, just by its definition under case law, is just an open and obvious condition that is static with nothing preventing a person from seeing it, such that a landowner may safely assume his invitees will see it and recognize the risk.
I get that, but safely assuming that something, and this is why I asked initially about where things are placed, because in a retail store, like I said, your upper body, I used to work retail a long time ago, and your upper body, like they're going to place things from probably waist up that they really, really want you to look at. Things below that are probably things that they don't care a whole lot about. But waist up is where they really want your attention focused, because that's where they're going to put the high-end products. That's where they're going to put the things that are name brands. That's where they're going to put the things that they really, really want to sell. And so they're going to draw your attention up to sell the more expensive and more premium products waist up. If the person is walking around, they're not going to be walking around in a store where the whole point is to have your eyes drawn to the merchandise with their head down for a stool that's only 10 inches off the ground. And that's why I asked for clarification, because when you said a stool, we could talk about a stool that sits at the counter for you to sit at the counter and fill out paperwork, or, complete a transaction, or something that can be moved around and assist someone. So I don't know that I believe that the argument that it is a static condition just because it was sitting there and it's in the open, a lot of things can be floor, like close to the floor, and people will be looking ahead and not see them. And so that's the difference for me, is that this is not a place where they were, showing vacuum cleaners or selling Roombas where they're roaming around the floor. And she should have seen that there was a Roomba coming because she's in a Roomba sales floor. This is a place where naturally your eye is going to be drawn from waist up because you're buying products that they have displayed, and you can see all the hats on the counter. If I'm looking for a hat, and my eye is going to go straight to the hat, not to the stool in front of the counter that's way below the hats. And so that's what I'm just saying. I get that there's no particular time where a condition becomes static if it is open and obvious. But my issue, I think, with the argument is whether this was open and obvious such that she should have visually appreciated it under the circumstances.
So, Your Honor,
to your point, there is testimony in her deposition where she was asked, where were you looking in the moments before your fall? I mean, that's a pretty important question for premises liability. And she just says, I was amazed at the store. I was looking around and I was talking to the cashier, I'll be back.
She does not recall, actually.
I'm reading from page 53, line 14. You asked the question, where were you looking in the moments before your fall? I was amazed at the store. I was looking around. I was talking to the cashier, I'll be back. I can remember like some stuff, but I'll be back, I love the store. I know I was talking and I was walking. So the employee's behind the counter. Obviously, she's not talking backwards over her shoulder. She's presumably looking at the cashier as she's starting to turn to walk out the store, like most people who say, hey, I'm looking forward to coming back. So again, the argument can be made to a jury. It's just in this case, we've got a situation where this isn't a summary judgment.
Your Honor, I did ask her in her deposition. I believe it's in page, I don't remember the page number, but I know it is in there. If she was actually looking at the cashier while talking and leaving, and she does not recall.
She says, I could have been. Line 23, page 53. Answer, I could have been.
Yeah, you could have been. It's equivocal.
But you're saying, you're arguing to the court that's not literally what you just said to the court. She doesn't answer, I was not. She says, it could have been. You asked, were you walking with your head turned towards the cashier? It could have been. It could have been because, I was saying bye to them and, walking out the door. That's what she testifies to.
Okay. All right. Well,
Your Honor, just going back to your points, though, again, there is absolutely no evidence in discovery that would suggest how long the stool had been in its present location. It is just assumption. Yes, plaintiff's counsel points to Ms. Serrano's testimony, but she could not state how long it had been there. Neither could the plaintiff.
But you said in your argument that it essentially was there for 30 minutes. So that's what I'm saying. This doesn't.
So, and I'm making that argument because that is, I think that is what we have to take it, because there's no evidence to say that it had been placed there while the plaintiff was in the store. Even when viewing the evidence,
the lack of evidence is not evidence.
Well, it is whenever it's the plaintiff's burden of proof to show.
I asked the employee point blank, and she says, "I don't know." So.
Yeah. All right. Like I said, I'm going to.
There are a few more issues, though. I wanted to respond to plaintiff's counsel, on, Your Honor. Whenever he points to Ms. Serrano's testimony, I want to point to the court that Ms. Toronto actually did not see. She saw the plaintiff and then saw the plaintiff like fall to the ground. She was behind the counter and I don't believe was able to see the plaintiff's feet or see the floor in front of the plaintiff as it fell. And it was only after she came around the counter that's when she saw the plaintiff on the ground and the stool in the area. Plaintiff's counsel brought up the issue of the shopping bag. Again, going back to the distraction doctrine, it needs to be the distraction needs to be something that is placed there by the property owner, the property possessor. There is no testimony, there is no evidence that the plaintiff claims that the bag was obscuring her view or otherwise preventing her from seeing the hazard. And then just going to just the most important points, a property owner or property possessor is not required under Georgia law to keep the property free and clear of any and all hazards. Because of the static condition doctrine, the prior traversal doctrine, it's only those hazards in which the property owner or the property possessor should reasonably, or believe with the exercise of due care, remedy those hazards in which the invitee would not be able to discover or otherwise identify. It's usually like the hidden or concealed hazards, because otherwise would make the property possessor, the owner, insurers of people's safety on the property, which is something that Georgia courts just have consistently not been willing to do, because people can fall on the most perfect of floors. So that's all I had, Your Honor. Thank you.
All right, thank you.
Your Honor, I have no other business in front of the court.
All right. That's actually it. This is one of the cases where Judge Hayward's going to mail out her ruling, or however that works. I don't know. This one was a little frustrating. It got a little long. That first one was too. I think I need to retitle this video just court cases that never end. Anyways, that's it. Thank you all for being here. Biggin, thank you again for the raid. Thank you all for the super chats, the gifted memberships, the membership milestones. You guys are awesome. I do appreciate it. Oh, let's go see who we can raid. Let's go see who we can raid. It being Sunday night, I don't know if anyone's going to be on, but we might get lucky. Oh, Credence and Mikey's on. I guarantee the second I go over there, he's going to end it. Watch. But we'll raid Credence and Mikey. All right. You guys are awesome. That's it. That's all I got. Tomorrow night is Members Monday, so I'll see all the members there, hopefully. And yeah, court's back in session tomorrow. I can't wait. Excited to get back to work. But yeah, that's it. That's all I got. Go tell Credence and Mikey I said hello. Till next time, bye.
May we be excused, or may I be
You
excused?
may. Thank you, gentlemen.
Thank you, Your Honor. Have a good day.
You too.